SJC-13807, the Workers' Compensation Rating and Inspection Bureau of Massachusetts versus the Commissioner of Insurance.
Attorney Allison, whenever you're ready, take your time.
Good morning. May it please the court. The administrative record in these cases may be complex, but the issues on appeal are familiar to this court. The W. Cribbs challenge rests on basic principles of administrative decision-making and the statutory standard of review. And the most fundamental problem with both of the decisions under review is that the commissioner gave no reasoned explanation for a decrease of 14.6% in workers' compensation rates. The commissioner imposed that decrease in the 2024 decision and held it in place in the 2025 decision. In the 2024 decision, the commissioner addressed this decrease in a single sentence in the conclusion and said, as each party has asked for a rate reduction, we must conclude that the rate is excessive, and so we are going to order the rate decrease under 53A8. That's it. There is no explanation of how he arrived at that negative 14.6 number, and there's no explanation of it in the 2025 decision either. The commissioner's brief on appeal sheds no light on this number. It, again, just says, well, this is somewhere in between the two proposals. And he argues that it satisfies what he calls the minimal requirements of the statute.
May I ask you a question about this? Let's assume that we were to agree with you that this required some explanation. Is the solution simply to remand and ask for that explanation?
We've asked for the court to go further, respectfully, because we've also made an argument that the commissioner misapplies the standard of review. And that infects the entirety of the 2024 and the 2025 decisions, sort of invalidates the 2024 and the 2025 decisions. So we do urge the court to get to that question as well.
But wouldn't an explanation from the commissioner help inform even that question?
It may, but...
so doesn't that argue in favor of of remanding to find out how the commissioner arrived at the number? Because that may in some ways affect the other arguments you've made.
Without guidance on what the statutory standard of review means, I fear we will find ourselves back here right after the remand on the 14.6 negative decrease. The commissioner did address the statutory standard of review in the 2025 decision, but it's not a model of clarity, and it is inconsistent with the view of the W. Cribbs regarding what that statute means when the commissioner is acting as a rate reviewer, not a rate maker. And if the commissioner misinterprets, as he seems to, his role in the entirety of this process, then our view is that that's bound to affect the way that he runs the proceeding and decides the issues, which we think is what occurred here.
If I may ask you another question. The way I read the commissioner's decisions, it almost looked as though there were two components to the analysis. The first is, or maybe it's not the analysis, maybe it's the outcome. The first is, does the commissioner approve or disapprove of your client's proposed rate change? And then the second question is, if the answer to the first one is no, it disapproves of the proposed rate change, what does the commissioner do in terms of setting a new rate or determining what the correct rate change should be? I see those as two components to the decision, and your argument concerning the lack of explanation relates to the second piece, not the first piece, because I don't understand you to be arguing that the commissioner's disapproval of and I'm only saying your clients because I can't remember the acronym ever, but your clients.
W-CRIB is what we say.
Your, of its proposed rate decrease. The commissioner appears to have accepted that a rate decrease was in order, found fault with the calculation and the proposed number that your client came up with, and disapproved it. That part is, as far as I can tell of the decision, not challenged on appeal.
Well, that's not accurate.
Okay.
We might be talking across each other, so let me
Okay.
explain what I mean by that. We do challenge the commissioner's disapproval of the W-CRIB's proposed rate revisions, both in the 2024 and the 2025 decision, because under the statute, the commissioner's only role is to review the rates, not to set rates, not to fix and establish rates. And so to the extent that...
What about 53A8? Additionally, if the commissioner determines that any already effective rates are excessive, the commissioner, quote, shall order a specific decrease, irrespective of whether any insurance company or rating order is filed for a decrease. Doesn't he have a power to do? He doesn't just say you screwed up. He also has, if he at least provides an explanation, an ability to provide another rate, doesn't he?
Our views is that 53A8 does not obviate the need to apply the requirements in 53A2 for prospective rate setting, right? So 53A8 says if the then existing rate is excessive, the commissioner can order a rate decrease.
But that's what happened here.
Right, but that doesn't obviate the need for the commissioner to evaluate and review the W-CRIB's proposed prospective rate under 53A2. And let me just point out that
just because we're in the interest of time, there was several pages written about why, what I've been calling WCRIBMA, why that rate was not approved.
Well, let me just wrap up the answer to that, and then to the previous
Go ahead.
question.
Yeah,
and
sorry,
turn to
didn't mean
that,
to interrupt.
because I want to just highlight that in 2025, 53A8 is not even in play because the commissioner did not determine that the rates were excessive and order any rate decrease. There, the commissioner just held the rates in place, right? So even if you view 53A8 as obviating the need to address subsection 2, that's not the situation in 2025, right?
It feels to me that you're advocating a construction of all of this that is going to create a vacuum for the industry. So if the commissioner has the power to review and then disapprove of the rate proposal by CRIB, but you're arguing that then they can't do anything, the commissioner can't do anything more.
No, I'm not arguing that. So if the commissioner, I'm arguing about that the commissioner applied the wrong standard in reviewing the rate proposal. But that if the commissioner reviews the rate proposal applying the proper standard and does not accept it, yes, then the commissioner determines what an appropriate rate revision is.
All right, so assume that we were to conclude that the commissioner did just that, disapproved, and that disapproval was sufficiently explained and sufficiently grounded in the record to disapprove the rate proposal. So let's just take the first year here. Does your argument then in essence just boil down to the commissioner couldn't pick the 14.6% without explanation? Because you don't argue, I don't think, that the 14.6 was an unreasonable rate decrease. You just argue that it's unreasonable.
Well, we can't argue.
Or just argue that it's unexplained.
Yeah, we argue that it's unexplained, and that's the fundamental problem. We can't determine if the 14.6 is unreasonable because there's no explanation for how the court, how.
Well, you haven't argued that the Attorney General's or the rate board's proposals or suggested rate decreases were unreasonable.
Well, we do, because we argue that the commissioner should have adopted the W-CRIB's proposed rate reduction, because the W-CRIB satisfied the requirements of showing that that would not produce excessive rates.
But there, I think, so the fallacy I see there is that there may be more than one reasonable rate decrease, correct? And that's sort of embedded even in your own argument that it's a range. So, and you haven't, we could accept the proposition that W-CRIB's rate decrease, proposed rate decrease was reasonable, and also that the AGO's proposed rate decrease was reasonable.
You're precisely right that there could be various proposed reasonable rate decreases. Our point is that under the statute, the commissioner's role is not to pick which one is most reasonable or which he would prefer. His role is only to review the proposed rate of the W-CRIBMA and accept that rate if it is reasonable.
So here let's say we accept that the commissioner was within his entitlement to reject the proposed rate the first year, your proposed rate. You're not suggesting, are you, that he then cannot do anything?
No, we're not suggesting that.
Okay.
If you reach that conclusion, then the remaining problem is the failure to explain the 14.6% in the 2024 decision, and that infected the 2025 decision because it held the rate in place. I would like to address.
Can I get the specifics? Because I feel like, I was a single justice, and I feel like this is obviously going to require another round because there is no explanation for the 14.6, but there's also, you don't even address their lost profit argument in your briefing, right? And they say, but can I get to three specifics? Because I feel like your point that we're going to be back here without having accomplished anything. So the AG says you should use 5 years for both. You say you should use 2 years for one thing and 5 years for the other.
So yeah.
And then this court sort of put in the position of trying to figure out is that unreasonable or not? Is yours reasonable or theirs? How do we go about that?
So
I can't even understand. One is Medicaid related and the other is a loss indemnity. This is not the kind of thing the SJC does on any regular basis. So tell us how to answer that question.
So
Isn't that one of the prime fights of this whole case? And
it's an example that, I'm sorry, that
I'm just trying to get a sense of what the real fights are about. To me, this seems like a critical dispute. I'm not sure it's one that we're really particularly well informed to decide, but this is one of the reasons the rate proposals are so different, right? 5 versus 2. But then you're arguing consistency, but you're both arguing inconsistent positions. So I'm at a loss.
So we've used the loss development factors as an example of the problem with the way that the commissioner approaches his limited role under the statute.
Let me just, again, I'm pushing hard because they're gonna come up and say that you've cherry-picked the top 2 years, and they think that a 5-year look back is fairer. That is the kind of issue where we may owe some deference to the commissioner if they were actually acting consistently.
Well, that's the problem, right? And that's what can be determined actually on the face of the decisions
Neither
and
of you
prior
appear to be
decisions.
acting consistently. Tell me how you're consistent when you say you've got to use 2, but you're using 5.
I will. So here's why the commissioner's decision first lacks reasoned explanation or consistency on loss development. First, it is not consistent with his long-standing order on using the 2 years of data for loss development factors, right?
But you want to use 5 years on the Medicaid I'm oversimplifying because actually reading your briefs, I can't tell the difference exactly.
So the reason we treat that differently, let me explain. The 2 years to determine what they call paid losses. That is the losses that are expected to incur in the rate period based on lost wages and medical losses, right? That's what the 2-year loss development factor is measuring. The 5-year is measuring a different potential loss, which covers also case reserves for big case.
Why does it make sense to do 5 versus 2? Or why are they unreasonable in having 5 years for both of those?
So in the reason why the W crib treats it differently is because, and this was before COVID, they treated this differently, right? That the case reserves are handled dramatically differently across insurers. And so having the 5-year period evens out kind of those inconsistent reserve practices. Whereas the 2-year period, which is just meant to estimate what those lost wages and medical costs are going to be for the 2-year period, doesn't have that problem, right? And what you're trying to do there is look at historical data to determine what those losses will look like in the upcoming 2 years the rates are going to cover. The reason why the reason what the commissioner said in 2003 was that it is generally, we don't want to do ad hoc methodologies based on a given year.
Again, I'm not sure we're capable of resolving that issue, but go to the next one. Lost profits. They say your profit calculation is unreasonable. You don't even address that in your brief as far as
so they say that because we haven't addressed profit, the court shouldn't hear these issues at all. And that's not that.
I agree with you, but you don't respond to their point that you don't even address that they're incorrect or not. So don't we have to remand to solve that?
No, because what we're asking the remand for is 1, to get the reasoned explanation, and 2, to get instructions on what the standard of review actually means, right? That the commissioner has to apply, because for the reasons that we
find that hard. I know you're fighting over that, but we have all kinds of areas of the law where we decide whether a decision is reasonable, within a range of reasonableness, and then we don't substitute our judgment for that. And I understand that they're doing that to you, and then we're reviewing them, but it's just the specifics are what's really hard.
But and this is why I want to emphasize that we do not believe the court needs to get into the specifics of the record to determine if the decisions on their face satisfy the requirements of reasoned explanation and reasoned consistency.
We can decide without getting into the specifics whether 5 years or 2 years, and we can decide the profit issue, whether your profit calculation is proper or whether they're overstating it. And let me add the third one, and we can decide whether it's appropriate to take into account in this housing authority, you're pushing for allowing this nationwide standard to be a complement. They're pushing to have the SIG thing added to it. Both are sort of imperfect measures, and we're forced to choose between that too.
What we're asking the court to do is to conclude that what the commissioner did in those decisions is not consistent with.
Can I ask you a question about what I understand your argument to be on that score? So your argument on that score seems to be the problem in each of these various respects with the commissioner's decision is that the commissioner went beyond what he was supposed to do. He's allowed to look at it and say, is this going to be excessive rates? He went beyond that and said, he looked at the information and said, I think this is excessive because these 2 years are not representative. I'm looking at 5 years. And that, I think you think is okay. The problem that you're identifying is the commissioner went on and said, in the future, rate maker, you shall use 5 years. Is that your argument, basically, that the commissioner's decision in each of these respects is wrong because it went farther than than just saying that it was excessive and actually decreed how you shall do rate making in the future. Could you answer that yes or no? Because I have a follow-up question. Is that part of your argument?
That is accurate, that it's ad hoc decision making, but we also don't agree with him using 5 years in this particular year.
Understood. And I didn't mean to drill down to the specifics of the 2 years versus the 5 years, but part of your problem is that he's saying in the future, do rate maker, do it this way. And my question for you is, and maybe this harkens back to Justice Wall-Hojan's question, is there really a difference there, right? If the commissioner is allowed to say, I think that this is going to lead to excessive rates because it's problematic for this reason, these 2 years are unrepresentative, isn't it helpful for the commissioner to give some reason, to give some explanation about what, would be more reasonable?
You mean helpful if we get that on remand? Is that what because we feel like the commissioner did not engage in a discussion of why the proposed 2 years, which has been what has been used for the last 20 years, was rejected in a year where using 2 years made more sense than ever, in our view, right? It suggests picking a rate rather than evaluating whether the rate is reasonable.
Well, I mean, to be fair, the commissioner said 2 years, 2021, 2022, is experienced high level of loss for sort of loss development, I think is what you're focused on, right? So 2021, 2022, higher level of loss compared to 2020, 2019, 2018. So for these particular years, and it's the highest loss over the course of 20 years, I think is what he said. So he gave an explanation as to why 2 years for this year did not make sense. And so he gave the explanation. I'm sorry.
Sorry. Our view was that wasn't a reasoned explanation, and it wasn't consistent with what he said in 2003. And I'll explain why.
Well, I mean, you might disagree.
In 2003, when he evaluated how to address these factors, he said these factors should not depend on events that are not likely to recur in the future. That is precisely what the commissioner did this year. He decided these factors based on events that are not likely to occur in the future. COVID, right? And he actually ordered.
But then he added 2019 and 2018 to smush it out, for lack of a better word.
But the whole reason that the W crib was even making a filing in 2023, which led to the 2024 decision, is because the commissioner ordered us to, because COVID, he said, was an unprecedented change that would change the workplace going forward, indicating that the years before COVID were not going to be repeated because COVID is changing things. And we all know that the year of COVID was indeed unprecedented in the workplace. Yet then we arrive at the hearing, we've made the filing and said, yeah, like always, we're going to use 2 years. And we're especially going to use it 2 years this time because you've already told us, and we can all acknowledge that 2020 is not likely to recur, and that the way that the workplace, what was happening in the workplace prior to 2020 is changing. And you could see that in 2021, 2022.
So you think that because the commissioner said the 5-year look back makes more sense to me, that she is acting as a
fixing a rate instead of reviewing
by saying a 5-year look back on loss development factors is the right one.
It's an example of saying, I like this one better, but that's not the role the commissioner plays under the workers' compensation.
If you came forward with a proposed rate decrease based on an Ouija board reading, and the commissioner said, I'm rejecting this rate decrease because your methodology is unreliable, and in the future, you can't use a Ouija board, what would be the problem with that?
Actually, there would not be a problem.
Right.
With that.
So why is that not essentially, why isn't that essentially the commissioner has a range of operation in which they can lay out, so it's not that the commissioner can never lay out a restriction on a methodology to be used in the future. It's just that you happen to disagree with this particular methodology.
We disagree that based on the purported explanation in the decision, that he's properly engaging with whether the W. Cribs proposed rate was reasonable. If the W. Crib came in and said the Ouija board told us so,
Why
then
is-
there would be no argument that he'd have to engage in an analysis of that, right?
Given that
Here he
you're
did not.
using 5 years for something related, why is it, how can we decide that his use of 5 years for this in both? You use 5 years, including the COVID years, in the other calculation, right?
In the one that involves case reserves?
Yes.
Yes.
And again, maybe when I read through this record, I'll understand why that's reasonable there, but not reasonable on the other. But
Well, I mean, isn't it your point that you had used the 5 years before?
We'd used the 5 years before COVID, right?
Even for this
Whereas
loss
the
development
commissioner
reserves
is-
factor.
Right, whereas and so our,
But didn't you some point,
It's been consistent.
didn't you some point shift from a 2-year to a 5-year on the Medicaid one too?
after 2003, but long before COVID.
I understand, but so you're allowed to make shifts. It's not like you're always frozen to something.
We're not arguing we're always frozen, but what we're arguing is the commissioner explained why 2 years for paid losses made sense in 2003. And that explanation would indicate it made more sense than ever in these years after COVID. Yet the commissioner reversed course and did the opposite. And there's no way to reasonably align what he says in 2003 with what he did in these years. And they're also internally inconsistent because he's saying, we recognize that COVID is an unprecedented change to the workplace, yet he says, but we're going to put the COVID year in and go back to previous years that we all acknowledge are not likely to be repeated to even it out. I mean, that just internally does not make sense when he's faced with the rate proposal by the filer to which he's supposed to defer if it's reasonable, saying, we've always used 2 years and we're going to use 2 years because it makes perfect sense here to use 2
Okay,
years.
I think we fully fleshed that out. Thank you very much.
All right, thank you.
I'm going to give Attorney Hitt an opportunity.
May it please the court, Assistant Attorney General John Hitt for the Commissioner of Insurance, and with me is Rule 303 Law Student Coleman Smith at council table. I want to turn first to the rate decrease issue, the 14.6%.
Yeah, so there's no explanation for that. I mean, it falls somewhere in between 7.6 and 17%, but there's no explanation at all for 14.
Well, there is brief explanation, whether or not it's as
Well, what is it? Why 14? Why not 15? Why not 13?
well on the face of the decision.
Yeah.
It's
Which is all we have.
right. It is all that the commissioner wrote, but explains that the commissioner deemed the rate to be excessive.
Right, everybody agreed on that, but why 14?
Well, you had the parties proposing a rate decrease of at least 7.6% or 7.1%, whatever it was that the WCRB was proposing. You have the 17.1%, which is being proposed by the Attorney General's office. And so the number that's picked by the commissioner is 14.6%.
Yeah, so that seems somewhat random. It's it's in the middle of the two, not in the middle even, can't even say it's, I took, half. So there's just no explanation. So at the least, we need a remand to explain that, right?
No, I disagree, Your Honor.
No, we just
Because-
accept that.
But here,
How do we back into that number? I mean, I'm at a loss. That's why, I'm back to the single justice session. How can we possibly make sense of this? You've not explained it. I mean, if we do are you expecting us to rejigger the 2 years versus the 5 years? And that'll somehow get us back to 14%. I mean, I just don't know how we do this.
okay, so all they're seeking in terms of relief is a remand back to, in essence, have the commissioner show the math and to explain how the commissioner got to 14.6. There's no argument
That seems important.
but there's no argument by them, Your Honor, that the 14.6 is somehow an unreasonable number. All they're complaining about is that there wasn't an adequate enough explanation. So when you read the face of their brief,
Right,
they
so
never,
at least a remand for the explanation.
But they never-
Do the math, show us the math, we'll be fine.
And they go further than that. They say you're wrong on multiple you're wrong about doing the 5 years versus the 2 years. They don't just say 14 points. I mean, they don't just say you don't provide an explanation. They say some of your explanations are wrong.
Well, now we're going off to a different topic. I'm at the moment addressing the 53A Section 8.
To me, they're interrelated. Your mistakes and your lack of explanation are interrelated if they are mistakes.
That is only the case, Your Honor, if you start from the premise that the commissioner was impermissibly acting as a rate maker here, which is not what was happening.
I agree with you that you have the ability to say their methodology is wrong. And had you done the math, maybe we could say, okay, if I did a 5-year versus 2 year, it actually produces 14.6%. But you don't do any of that. All you do is say, accept what we want.
But Your Honor, it is a two-step process. So first, there's the issue of whether the commissioner approves or disapproves the rate filing. So that's the first step of the analysis. Then you move on to the second step of the analysis. So here, the rate filing was disapproved for multiple different reasons: the loss development factor, the underwriting profit provisions, and also I believe as to the F class issue as well. The fact that the WCRB has not challenged the underwriting profit provision means that there's a basis on which this court can easily affirm the decision of the commissioner. It's not challenged.
We can affirm that they didn't. We could say, yes, you waived the argument about the underwriting profit provision, but that doesn't mean 14.6 is right.
But again, these are two different issues. So the rate filing is still disapproved, and that's the first step of the analysis. So there's still a valid basis for disapproving the entire rate filing because they haven't challenged the underwriting profit provision. So that ends at the first part, step one. We're done there. Now the commissioner is faced with the language of the statute, which says, okay, if rates are excessive, if I have to go through this analysis under 53A Section 8 and determine if the current rate is excessive. At this point, the WCRB has already conceded that their rate is excessive because they're seeking a decrease in the rate filing. Even though the rate filing has been disapproved, the commissioner still has on the record and in the record before him the fact that the current rate is excessive.
But a concession that it's excessive to the extent of 7.6% is not the same as a concession that it's excessive to the point of 14.6%.
Well, but the statutory analysis is to first determine whether or not the rate is excessive. The commissioner has determined the rate is excessive. The statute then orders the commissioner shall order a specific decrease in the rate. So at that point, there's no guidance from the statute in terms of what number the commissioner is supposed to use.
You can pick whatever you want. You could give them, you could say, okay, no money, 0. Obviously, there's got to be what you have to do has to have some reasonableness to it too, right?
Well, again, separating out the standard that's applied to the commissioner and ensuring the commissioner is not acting as the rate maker is different than when the commissioner exercises the decreased power.
So imagine we have to just guess because we don't have any reasons for the 14.6. But imagine for purposes of my question, and I assume this, and I'm saying this is a big assumption, but assume we were to find a lack of reasonableness in what the commissioner did on the 5 years versus 2. And then we remand, and lo and behold, the way that the commissioner came up with the 14.6 was precisely to use the 5 years instead of the 2. I take it that they're different parts of what the commissioner does, but they bleed together because on the record before us, we do not know what went into the 14.6. And assuming there was error in some of the commissioner's analysis on the other issue, that could have fed into how the commissioner came up with 14.6, could it not?
It could, Your Honor, but again, here you have on the face.
Well, isn't that the end of it, though?
No.
Don't we have to decide? You were arguing that we should just not even decide any of the issues relating to the reasoning of the commissioner's decision up to the 14.6. But shouldn't we do that? Because otherwise we're just going to send it back and then be back here all over again?
But again, Your Honor, there's going to be a new rate filing in 2026. We're back on the cycle of when the next rate filing is going to happen. So the parties are going to be back in the normal course under the statute, moving on to the next new rate filing.
There's going to still be this issue of whether you overcharged or undercharged, right? There's always going to be another filing. there's going to be one for the next 300 years. What does that get us?
Again, in terms of the relief that's being sought here, in terms of just a remand for further proceedings, and with it being limited to the issue of just explaining the math of the 14.6 rate decrease under 53A Section 8. So again,
We have to decide whether I mean, again, it's hard to figure out what you're fighting about, but it seems like we're fighting about at least the profit calculation, the 5 years versus the 2 years, whether you can take into account, whatever they're called, the rating bureau can take into account the national information, or does it have to take into account what you insisted, this SIG data, which is, and again, it's not even for the person being rated, it's the competitor of the person being rated, which is really problematic to me. And don't we have to decide all those issues to provide any meaningful guidance to you? Or can we leave it? Don't we have to decide all those issues either in your favor or their favor?
No, Your Honor, because
Really?
the statute orders the commissioner to make a rate decrease if the current rate is determined to be excessive. That's a completely different analysis and calculus than the substance of the rate filing itself. So the statute gives the commissioner discretion to set a rate decrease, not discretion, shall order the specific decrease in the rates. The number that's proposed here is on its face reasonable because it's a number that's between the two numbers proposed by the.
Suggesting it just speaks for itself?
Wow, that's a really.
That's interesting.
That's again, Your Honor. It's it's a number that's.
So let's just assume that we disagree with you, that the only thing that we need to decide is the 14.6 and that it fell somewhere between 17 and 7, and therefore it is almost obviously reasonable. Why can you address the loss development factor in the 5 years versus the 2 years in light of the 2003 decision?
Yes, Your Honor. And I'll just add that the 14.6% number is based in evidence in the record.
Yeah, but it's not explained anywhere. I have to go find it, and I'm not an actuary, so that's a problem for you. But going to the 5 versus 2, why is that within the standard of review of the commissioner to determine whether W. Kribma's proposed rate falls within a range of reasonableness? Why is it within his statutory authority to say you should use the 5 years in light of the 2003 decision, which
Yes, Your Honor. So what's set forth in the 2003 decision simply said that for that rate filing in that year, that it made sense to use 2 years versus 5 years of data. It just happened to be the case that over the course of the next 20 years, this issue, whenever it came up in each of the various rate filings, was either resolved between the parties.
My understanding from opposing counsel is that the reasons why the shift to the 2 years in 2003 make even more sense now for post-COVID. So can you just address that specific argument?
Yes, Your Honor. So at some point, the WCRB on its own started to use 5 years of data instead of 2 years of data for certain portions of the loss development
So let's
factor.
just stick with the one where it's been 2 years of data for the since 2003.
Yes, Your Honor. Yeah, right. So in reviewing this rate filing and based on the testimony in this proceeding and the evidence that went in both by way of pre-filed testimony and then cross-examination of the witnesses, there was evidence in the record that showed to the commissioner that using 5 years of data for both categories of loss development factors was the better way to calculate the rate and determine.
It's the better way, right? Is that taking on a rate maker hat as opposed to, is this within the range of reasonableness? So address that.
No, the commissioner is not making the rate, but still.
What's the difference between saying you have to use 5 years and here's the rate?
The difference is the methodology. The commissioner still has the statutory authority to review the methodology and ensure that.
Does he have the statutory authority to prescribe the methodology?
Yes, so long as it's done in a way that comports, it meets the reasonable consistency standard under the law, and also is done in a way that explains why the commissioner is proposing a different methodology be used to determine the reasonableness of the rate filing.
What's you think the best case for you that clearly, based on our case law, the commissioner can say that the methodology used in the rate filing produces excessive rates. But what is your best case for the proposition that you can not only say, rate maker, your methodology produces excessive rates, but you can then go on and say you must instead use this methodology? What's the best case for that?
Your Honor, I believe it would be Attorney General versus Commissioner of Insurance, as well as.
Yeah, but that case, just to stop you on that case, the commissioner suggested methodology to be used going forward, did not prescribe it, which is why I used the verb prescribe specifically.
Well, again, here, Your Honor, the WCRB had already shifted on its own to using
for a different loss development factor analysis regarding reserves. It had been using the 2 years since 2003.
But this was the first time that the commissioner was reviewing the use of the 5 years. It was writing a decision on the issue of the use of 5 years versus 2 years. So the commissioner indicates that the commissioner is determined, based on the evidence in this proceeding, that using 5 years of data versus 2 years of data leads to a more consistent and reasonable rate. That the methodology, that the use of that data ensures that the rate is going to be.
I guess it would be helpful to me if you could explain to me why 5 works now and is required now, as opposed to for the last X years since 2003.
Well, again, Your Honor, each year the commissioner is looking at it based on what the record is before the commissioner in those years. So when you go back,
there's supposed to be a consistency across years, and I guess that's.
But there has been a consistency across years.
Until this
so the 2003 decision, when you read the face of that decision, it indicates that for the year 2003, the commissioner is using 2 years instead of 5 years of data. But based on the testimony in that case in 2003, but in the future, it may make sense to look at a different period of time instead of 2 years. This just happened to be.
Can you also? She argues that they're not being inconsistent by having 5 years on the Medicaid one and 2 years on the other. Tell me why that's clearly wrong.
Well, there is testimony in the record from the Attorney General's expert, Dr. Schwartz, that goes through and explains why using 5 years of data instead of 2 years of data is the better approach. And that
No, they make a different point. They're arguing, I'm trying to understand why they accept 5 years works in one context and doesn't in the other. You're saying 5 years should be applied in both contexts. To me, your best argument is that you're being consistent. You're doing 5 years in both contexts. They say that doesn't make sense, and I don't understand their argument, but why don't you tell me why they're wrong?
Because as the commissioner explained in the decision, looking at 2 years versus 5 years, from an actuarial standpoint, throws off the calculus looking forward in terms
They're
of.
saying they're two different things, though.
They may be saying that, but the evidence doesn't necessarily.
Is that wrong?
It is wrong, Your Honor. And as the commissioner explains, the commissioner, based on the evidence before him, determined that using 5 for both different categories of the loss development factors was the reasonable approach and the methodology that should be
You
used.
win on that point because, I mean, to me, that's one of your stronger arguments. But
yes,
and what does that get you? If I were an actuary, am I going to be able to figure out how that increases, how that decreases the rate? Again, I'm not an actuary, have no intention of becoming one.
I believe so, Your Honor, that in the record, when you read the testimony, that there is explanation of how it does impact the rate. And the issue is the issue
Is that
of
something you can agree on, by the way? Is that something that both of your actuaries agree on, the effect of 5 years versus 2 years? Or is that another one that'll be back here 6 months from now?
I can't answer that, Your Honor. I mean, obviously, we're here.
So if you can't answer that, how can we answer that?
Well, again, this is why the court should defer to this is why we defer to the expertise of the commissioner in this type of a rate review matter.
That's why we demand an explanation.
Well, again, Your Honor, there is an explanation. It may not be a long explanation, but there is an explanation of how the commissioner got to the 14.6%.
For the other one, because again, you're leaving us this sort of miserable technical question, which is you are insisting they include the self-insurer group data. They provide a good explanation that these people are not regulated the same way the rest of the industry is. Furthermore, they're getting the rate they asked for. What they want to do is change their competitors' rates so that they're more competitive. Isn't that one where we say, wow, they seem to have a better argument here, particularly when you're not supposed to set rates and you're dictating to them that they should include problematic data in their calculation. Don't they have the better argument on that?
No, Your Honor, it's not problematic data. And again, the commissioner is not has not set a rate here. The commissioner is simply...
You're telling them to put into this data. They use this data on national information, which you say they shouldn't be doing. By the way, I think you make a pretty good point on that. But then they say, well, okay, you're insisting we use even more problematic data, and it isn't even and it's people who aren't even being rated. You want to use that data for their competitors. That seems like they have got a good argument on that.
Well, that may appear so, but when you actually look at the argument, it doesn't make sense.
Better help me, because I'm going to have to look at the argument right now. It seems like they've got a good argument. I don't understand.
Well, because again, the commissioner is looking at the methodology for setting the rate in Massachusetts, and if you're using a universe of data from other parts of the country that are not reflective of this,
those people that you want to, the people whose rates you want to take into account, their rates are being raised, right? The commissioner has given them the rates they want. What they want is to use those higher rates for their competitors. And that seems like you're doing just what they're doing, which is you're sort of jacking things up for reasons that aren't based on facts.
The commissioner is exercising the commissioner's statutory responsibility to ensure that the rates are reasonable, the methodology is reasonable. And here, when rates are being set for a particular class code that's using data that has no relation to what's actually happening on the ground in Massachusetts in terms of the group that writes 85 or 87% of the policies in the Commonwealth, the commissioner is simply saying you need to take that data, which is what is actually happening in Massachusetts, and use it as part of your credibility complement to make sure that the numbers you're giving us on your rate filing are in fact accurate, and that you aren't setting your rate based on countrywide data from other parts of the country that doesn't reflect what's a reasonable rate in Massachusetts. Again, these are complicated issues, and this is why a case like this hasn't been before the court in 50 years. But when you look back at the WCRB decision from 1984, there's a wide berth given to the commissioner so long as there's support in the record. And I will point out here that there has not been a substantial evidence challenge mounted by the WCRB relating to this decision. That when you look to what's in the record to support the commissioner's decision here, there is support in the record for the commissioner's decision.
Can I start just one quick question following up on that? So in asking that they look at the data of the SIG, That's not asking that they look at the rate of the SIG, the rate requested, right? It's underlying loss and claims data, is that right? What data exactly are they being asked to look at?
They're being asked to, in the future, include the credibility complement, which is a body of statistical data that exists in Massachusetts, but is not used to determine the rate that the WCRB sets. So the commissioner is simply saying and has done it just as the commissioner should do by way of announcing prospectively, I want you to use this methodology in the future. We think this is the better way for you to
And then, sorry, a follow-up question. There's all this reference to a state special rate and sort of not looking at national data and instead just focusing on here on Massachusetts. Does the commissioner, and there's a suggestion in the briefing that this is, well, is that something that NCCI does, or does the commissioner regularly decree that state special treatment should be given that disregards national statistics in favor of local?
I believe it's the commissioner that does it. If the court would like, we can submit a post-argument letter on that point if the court would like it. There's one thing I would like to mention before I forget. On the 53A8 point, there is a case that has not been cited by either side in their briefs that I believe is distinguishable but does have dictum on when the commissioner may order a rate decrease. That case is Associated Industries of Massachusetts versus Commissioner of Insurance at 403 Mass 37 at page 45. I bring it to the court's attention so the court is aware of it. And if there are no further questions, we will rest on our brief.